will be able to get some legislation done next year. Now it's not going to happen. Secure is not going to happen in 21. We're not exactly sure what's going to happen in 21. I'll talk a little bit about what's left in Build Back Better, and hopefully Ashley will be helping me with these slides. But I think putting aside the Build Back Better legislation, which, I think most legislative activities is a roller coaster, and this is by no means any different. I think if I had to bet, they'll still come up with something, but I'm not like feeling the super, someone was talking about poker. I've got a scary face around the idea of placing any bets at all. And this is gonna come down to the wire. And so if they do reconciliation, it's probably not gonna happen until very close, if not days before Christmas. And mostly because, progressives and moderates just, don't agree on what's needed. I mean, Manchin came out just yesterday and talked about one of the tax credits for electric vehicles and the fact that he doesn't think it's appropriate to give extra credits for or higher tax credits for cars if they're made in a union shop versus a non-union shop, and so on and so on and so on. So, I mean, I think, and obviously he's been down on paid family leave, which is a really important provision for progressives in the House. So I don't know what is going to come from this. No one really knows for sure. It could completely fall flat. They could come up with a deal. I do think if they do have a deal, we will see the Roth provisions included, and so I'll spend a few minutes talking about that when we get to that slide. But I do, the good news, the silver lining here is that there was some concern when some of the coverage stuff was included in Build Back Better that it might taint the environment for retirement policy. In a way, I keep on saying silver lining because I'm an optimist. The silver lining again for it being taken out of Build Back Better, as much as it was somewhat disappointing that it was, that it actually helps in the long run maintain that bipartisan environment for retirement. And we're not going to give up on the coverage issue, as I'll talk about in a second. So if you're there, Ashley, can you proceed? Oh, there you are. The magic arrow. Next slide. So a lot of you may be familiar with these, so I'm going to go through this just very quickly. But retirement policy concerns remain front and center for policymakers in DC. Consistently, polls show that it's the number one concern, financial concern for American families, and that's increased quite a bit over the last 5 to 10 years. And a lot of it's because the healthcare world has been, in large part, at least addressed in terms of coverage with ACA, whereas there's a lack of coverage in the retirement space. And so if you go to the next slide, it's, the good news is that we know how to fix it. And that's getting people covered by plans. 2/3 of folks who are in plans make less than 100,000. If you go to the next slide, and that's because, as advisors, you guys do an amazing job taking care, encouraging through education, participation in the plans. And particularly with automatic enrollment, we see fantastic take-up rates and stickiness to participation. I mean, the workplace savings plan works. there's no debate around that. All parties, Republicans, Democrats, independents, doesn't matter, all recognize that workplace savings plans work. Next slide. So it's that lack of access, that coverage gap, that's particularly problematic, particularly for communities of color. And then if you go to the next slide, what that translates is a wealth/savings gap, a racial inequity that's pretty pronounced when you're talking about 2/3 of Hispanic families with no savings, and almost 60% of Black families compared to only 1/3 of white families. And the only explanation for that is coverage. And in particular, among Hispanic communities, as well as Black communities, there's a preponderance of folks who are working for smaller businesses, a lot of entrepreneurs in the Hispanic communities. And those smaller businesses tend not to have plans. There's also, people don't appreciate how much of a distrust exists in the financial services system among communities of color, which is a barrier. And one of the reasons I'm so driven to expand coverage is, for many of these people, it's the first financial account. The 401k is the first financial account that they ever have. They don't even have a checking account. And so being exposed to a financial account opens the world up for them to other financial services, not just from an opportunity to sell standpoint, but really just for them to grow wealth, generational wealth. I was talking to a NAPA member in Arizona who's younger. He's only 28 years old. He's a great guy. He's Hispanic 401k advisor in Phoenix, and he's really doing well. And he's got a client who's got a corporate farm near I forget exactly how close to Phoenix it is, but he did an enrollment meeting, and it was just a new client for him. The line was out the door of people, one, because he spoke Spanish. The first time they had someone to do an enrollment meeting who could speak Spanish, but secondarily, it's the first time they've ever talked to a financial advisor, and they really wanted to talk to him to get his thoughts about saving in the plan and where to invest. And it was just, for him, he said it was just so gratifying to not only, make a living, but do so by helping people in this community. So that's what coverage is about. It's the opportunity to expose so many more people, millions of people, what financial services could bring to the table in terms of for themselves as well as their families. All right, so we know how to fix this, right? We know how to fix. Let's go to the next slide. We fix this by expanding coverage. When you have people covered by a plan, and you particularly do automatic enrollment, you see no racial disparity in savings. You do see disparity based on income, which you would expect, but not based on race. And so, access to a plan is the key. The problem, I'm going to skip ahead a little bit, go to the next slide, is that this is fun. The problem is that there's not like most things, everyone agrees that coverage is the solution, but no, there is an agreement on how to effectuate, how to get to that solution. So there are states, and there will be more states probably next year, that are going to require employers to have a plan. and certainly the federal proposal that was in Build Back Better but got dropped out because of, they had to cut it in half, would have addressed it at a national level, but that was a partisan approach, because Democrats want to do more of a stick approach, Republicans want to do carrots. And that's really the difference. is they all both agree we got to expand coverage. It's just how do we expand coverage? So either way, even if, and I'll get to where I think we're headed with Congress, regardless of the fact that that was dropped from Build Back Better, you still have a bunch of major states, and New Mexico just announced an agreement to piggyback with Colorado this week. You've got Oregon and California, Illinois online, Virginia, New York, and Connecticut and New Jersey are going to be online in the next 12 to 24 months. You still have a lot of big population centers where there is a requirement to have a plan. It's important to recognize these proposals are twofold. One is the requirement to have some type of plan. Oh, and Hawaii next week's going to vote to piggyback with Oregon. I just found that out like this morning. There's the requirement to have a plan, and then there's the state product, the payroll deduction IRA product. And so if you go to the next slide, what we're finding, one is this thing works. This is Oregon, 3 years since the program has been initiated, over $120 million in assets, all through automatic enrollment, and pretty much the pandemic hasn't stopped it. When you go to the next slide, what we're finding is that employers really don't mind the mandate. They're really not incurring significant out-of-pocket costs. But also what we're finding, which is going to be interesting to folks listening today, is that this has driven new client work for advisors, that there are businesses saying, I don't want to send the money to California or New York or Oregon or wherever. I want to have my own plan if I have to have one. And so what we are seeing is data that shows that there's a lot of new startup plan business coming out of these states. So that's a good thing. So if you go to the next slide, let's see where. So let's actually, this is fine. Let's leave here. This was the proposal that was dropped. And the reason I'm leaving this up is because what we're going to try to do is take pieces of this and bring it to secure. And so what we're discussing is kind of a combination of super carrots and maybe some type of mandate above a certain threshold as a market driver. Let's just say 100 employees or more, where they would require to have a plan. But below, we would supersize the credits. So right now it's a $5,000 credit each year for 5 years, but that's for the cost of the plan. And then we may give a credit on top of that for smaller employers if they're willing to do it. So not only will we cover all your costs, we'll just give you a $2,500 bonus for doing a retirement plan for X number of years. And then couple that with what is now going to be called the starter K, which is really this deferral only. It's a proposal that's been around several years. It was actually introduced first by Senator Hatch, who was the chairman of the Finance Committee several years back. But we're going to reinvigorate that idea, which is similar to this third bullet on the left, this new 401k deferral only safe harbor, calling it the starter K. But the reason this is important, folks, is that it's a deferral only 401k platform product, no testing, no top heavy, no ADP testing, maybe a little bit higher limit than IRA. So let's say it's an $8,000 limit, $2,000 catch up. And now in those states that have to have a plan, our industry has a product, whether you put it in a MEP or a PEP or a GOP or whatever. But the point is, it's a low-cost alternative because the payroll deduction IRA is not very, states are doing it. It's very awkward for the private sector to deliver that product given the banking rules involved and the paperwork associated with it, as opposed to a 401k platform product. I think you all would agree. So we are already in the process of talking to staff, and I've got a meeting with Chairman Neal coming up in a couple weeks, where we're going to kind of lay out the future of the coverage strategy and ways to see if we can do this on a bipartisan basis, maybe throw in some sticks and some bigger carrots, honey glazed carrots for Thanksgiving, and then couple that with a starter K that can be delivered by you wonderful people out there in a fairly cost-effective way to satisfy the requirement. So that's the overall arching strategy when it comes to coverage. And I'm actually feeling pretty bullish about the prospects of that, particularly given the fact that I think Secure 2.0 has a real good chance next year. All right, next slide. We can skip that. Skip that too. We don't know how much. We gotta come up with a proposal first before we decide. All I can tell you is it's tens of millions of people. How many tens of millions of people? It depends on exactly how this proposal gets crafted. So we'll hold on to these data points until we have a better sense of when this thing's going to happen. But there's a lot of people out there who need retirement savings, and I think that much we can all agree on. Next slide. Next slide. And a lot of employers who need plans too. Next slide. All right. So the Roth stuff. Let's see where we're at. The good news is that the things that were not working at all, which are the two things on the right after the backdoor Roth, were taken out. We had pointed out to them the way they drafted it. In fact, differential share classes would not have been allowed in IRAs. I mean, it was really poorly drafted. So they've dropped it. But they have reinstated the $10 million cap, the requirement to disgorge assets above 10 million, and importantly, the elimination of backdoor IRA. Now, some of you may be using that with clients. It is effective in 22. That is very concerning, because if they end up doing this bill, which again is if, but if they manage to get their act together and come up with some agreement between progressive and moderate Democrats, that's likely not going to happen until well into December. And that's just not going to be enough time to shut the train down for these after-tax contributions. So I have been impressing upon them the fact that if they feel the need to go down this road, that it really needs to be pushed back a year in terms of its effective date. I can tell you that they didn't say no, and I think they understood the point I was making, but they didn't necessarily say yes to. One of the problems is it changes the score, and everything is very sensitive around the total cost of this bill. So any slight variation in score is causing major heartburn. So my expectation is that if the House gets its act together and passes a bill, that the backdoor Roth provision will still be effective in 22. Our shot to fix it is really in the Senate, where this bill is really going to be shaped. And frankly, they're running out of time. It is, by the way, one possibility is that reconciliation bleeds over to January. And there is actually no real reason it has to be done this year. Sorry, done in December. And I think a lot of the media seems to be fixated on the need to get it done by the end of the year, but there really is that's an artificial deadline. The real deadline is the fact that there's a continuing resolution to fund the government through the beginning of December, and the debt limit is somewhere out of money to pay our bills mid-December-ish. And so those are the things that need to get addressed. And I'll be frank with you, if I lose sleep over something, it's the debt limit, because Republicans have committed to the fact that they're not going to work with Democrats to extend it anymore. So I am exceedingly troubled by how they're going to address this. Not that I'm trying to scare you on a Friday afternoon, but I wanted you to share in my misery. And the reality is there is currently no real clear path as to how they increase the debt limit. And so we are probably going to be releasing a study in the beginning of December about what happens to retirement accounts if they don't pay their bills. It's like basically not making the minimum payment on a credit card. It's not a good thing. And if we think the Chinese are going to let us get away with it, we're kidding ourselves. So the long-term interest costs to the country and the impact on accounts is scary. Well, on that happy note, let's talk about Secure. And Tom, help me out. How long do you want me to go for?
Brian, you can take up. We're scheduled up through 2:30, so you have plenty of time.
Plenty of time. So let's talk about the stuff that's insecure. If you go to the next slide, Ashley. Oh, we're going to do ESG first. Never mind. So let me talk a little bit about this, because I'll tell you what, let's go to secure and then we'll come back to this. Let's go to the next slide. All right, stick with legislation. Go on, please. As I said, the good news is that it is bipartisan still. I do think that the prospects for this next year are excellent. You've got a situation with Kevin Brady, was the guy on the right to Richie Neal, has already announced his retirement. Rob Portman's retiring. So I continue to think that as a legacy issue, the fact that probably by spring of next year, it's going to be hard to do anything legislatively unless it's bipartisan, really helps us kind of start to pave the way towards seeing this through the goal line. The most likely scenario would be it would actually pass in lame duck, but the work would get done during the second half of next year. So I talked about the things that we're going to try to juice up from a coverage standpoint. There's also a provision that would require all new plans to be automatically enrolled. So that could be coupled with this sort of super carrots, maybe a requirement above a certain size. But policymakers, and this is really bipartisan, they recognize the impact that automatic enrollment seems to have. It works very effectively. And so you're going to see more and more of a push. No one's talking about applying this to existing plans right now. So don't want to scare you yet. But I do think, dial the clock up a few years, you're going to start seeing proposals to require plans to do automatic enrollment. Favorite for the 403B crowd is allowing it to invest in CITs. The changes to RMDs. I have a feeling that these kinds of things might drop out for cost reasons, particularly if they end up doing more on coverage, which is higher priority from a policy standpoint than RMDs. Also, there's another RMD proposal that's like a safe harbor that Portman and Cardin like, which I'll talk about in a second, that I think has probably more legs. Catch up, increasing the catch up limit is something that is seen as in many respects as a women's issue, because women go out of the workforce and then come back in for family reasons. And so, giving some opportunity for folks to be able to catch up. This is very limited, just to 3 years. I think you could see a broader proposal for a higher catch up. Maybe this is only eligible for ages 62, 63. It's got a little window, 3 years to do higher catch up. I could see that expanding under the next version of this bill. I mentioned 403B PEPs, which was, I think, an oversight in Secure One. And so I think they're in the nonprofit world, being able to do a pooled employer plan makes a whole lot of sense. Next slide. So another fan favorite among plan sponsors and advisors is allowing for the payment of matching contributions into a plan but keyed off of student loan payments as opposed to deferrals into the plan. There's a private letter ruling that kind of, awkwardly allows this. It's not really flexible. This would make it a true matching opportunity. There was a problem with the original proposal that we have been able to correct. That problem being that for those of you who are ADP test aficionados, if you are, giving matching contributions, but your employees aren't saving in the plan, they're paying student loans, those are zeros for the ADP test, and zeros are, as you would know, a bad thing. So this would address that by allowing all of those folks getting matching contributions for student loan payments to be tested separately, and which should pretty much solve the problem. This was a PEP issue, section 110, allowing the startup credit to apply for existing PEPs. There was some question which we're waiting for guidance on, like other guidance that was mentioned before, to allow for if a PEP's been around for more than 3 years, would they still get the tax credit? So this would clarify that that's correct. Section 112 is really gamification. There's been a lot of folks, some of the folks on this call, that have liked this idea of allowing for, prizes, or, either a lottery or certain prizes if you increase contribution by X%. Those small financial incentives would now be permitted. Something that AARP has asked for, which is to bring that long-term part-term thing down to 2 years as opposed to 3 consecutive years. As we all know, the long-term part-time rules go into effect in 23. And so a lot of folks are trying to deal with how to implement that. I'm not particularly too fond of this because it would really, it particularly happens at the end of next year, upset the apple cart quite a bit. But we'll deal with that as the legislative process continues next year. Next slide. Retirement savings lost and found. This was also in the Rise Up Act that was marked up in the House Education Labor Committee. We'd like to try to improve on this a little bit, but basically, particularly allow for plan sponsors to get a safe harbor from fiduciary responsibilities that once they send the money to the PBGC, and just making that clearer. Another AARP request that's in this bill is a requirement to at least have one paper statement benefit statement sent to a participant each year unless they affirmatively opt out. So, under the DOL safe harbor, which we worked many years on, that allows for all benefit statements to be delivered electronically in a default basis. This would change that. Now, what we're negotiating currently, and there's a working group that we're participating in along with AARP and some congressional staff, is maybe trading this for applying the DOL electronic delivery rule to all IRS notices for 401ks, so that you would be able to deliver all of the stuff that IRS requires, like 401k safe harbor notices. And for that electronic delivery, that default electronic delivery rule, which is much more favorable than the Treasury rule, we would be open to the idea of trading one benefit statement in paper. So you can get an inside view in the exciting negotiations that go on between ARA and AARP, which pretty much is every week. All right, allowing separate application of the top area rules. So this is allowing for disaggregation of for top pivot rules of otherwise excludable employees, which is already allowed for ADP purposes. So what we're envisioning here from a consulting standpoint, going back to that long-term part-time employee issue, is that, there's a lot of companies, particularly service companies, that, they already have to count 1,000 hours. Making them count 500 hours is going to be really burdensome. So one idea would be, okay, just do universal eligibility, but you don't get any employer contributions until you meet the 1,000-hour rule. But the problem with that is you might have testing problems if you are not a safe harbor plan. Actually, this could impact your safe harbor plan if you're not providing safe harbor contributions. So you only be able to do this for now on a non-safe harbor basis. And so it could cause a testing problem, but if you could disaggregate all those otherwise excludable employees for top heavy and for ADP testing purposes, that would make that idea of addressing this long-time part-time worker thing be much, for some employers, a lot more manageable. And we're also going to work on a proposal in Secure 2.0, or the Senate version of Secure 2.0, that would actually allow you to do a safe harbor plan, but still allow for otherwise excludable employees to be eligible. So we can kind of combine the two. Yes, I recognize this is getting complicated. Sorry about that. Next slide. Family attribution, one of my pet peeves, just this idea that two people have a kid and they get divorced and they have completely different companies, but because they have a child together, they have to be tested together. It's nonsense times 1,000. So we're committed to trying to kill that crazy rule. And then another provision, which is keyed off of a provision that ARA was instrumental in getting. This is the new plan retroactive adoption, which for those of you in the cash balance world has really been a boon for those types of plans. This would have similarly, without having to create a new plan, allow for essentially a bonus profit sharing contribution after the end of the year that could be given, decided to be given after the end of the year, but still be deductible for the prior year. I think that if you go to is there another slide? Keep on going. Oh yeah, the pay fors. So so these are things that raised revenue to make this bill revenue neutral. And I want to highlight the ones on the right, just because what Congress takes away, they often give back. And the real issue with the backdoor Roth, people are like, why are they going after this? Besides its icky name, which obviously drew attention to it. Tax staff, particularly committee staff, they hate loopholes. And this is on their list of loopholes because it wasn't intended. I mean, I think we all agree that when in-plan conversions were allowed, this idea of doing these daily conversions or weekly conversions when contributions are made of after-tax contributions into Roth was not intended. And that makes congressional staff mad. So they want to repeal it, but then I think they're likely to give it back. And the way they're going to give it back is what I call the front door Roth, not the backdoor Roth, but the front door Roth. And the front door Roth is going to be this second provision on the right, section 604, which is going to allow for employer matching contributions to be treated as Roth, assuming the employer allows it as well, on an elective basis by the employee. I can say treat my matching contributions as Roth, and I'll pay taxes on them this year. And I see them expanding this to all employer contributions, potentially even profit sharing contributions. So in a way, you'll still, not exactly the way the after tax works. I think it was a lot more flexible than this, but you'll be able to approximate what you were doing there through the front door. And the reason they want to do it, frankly, is because they get the revenue for it. Whereas they didn't get the revenue with the loophole. It makes them mad. They'll get the revenue by allowing it through the front door. And the other thing that I would expect to happen as part of this bill is they will make catch-up contributions required to be Roth. And I don't see anything really stopping that at this point. I think that's inevitable at some point. I just hope they use it for retirement policy. So all told, this thing raises probably close to, if you add employer contributions, probably getting close to $40 billion of revenue, which can pay for quite a lot of the coverage stuff, in addition to the other stuff that's insecure. All right, so I'm going to make Ashley go back to the ESG slide. I'm so sorry. There you go. So I'm going to read you this sentence and you tell me what you think it means. This is in the preamble. Accordingly, the proposal makes clear that climate change and other ESG factors are often material. Climate change and other ESG factors are often material, and that in many instances, fiduciaries should consider climate change and other ESG factors. And so the concern that we have, and what we're going to meet NAPA members, we have a council of the home office folks from our broker dealers and RIA members, which is pretty much, a sizable percentage of the 401k specialist marketplace, is that does this thing go too far? The way I would describe it is as follows. Before, when the Trump administration rule was in place, there seemed to be a higher burden to be able to put a ESG type of investment on a 401k menu. You had to show that there's pecuniary factors. Now we've swung the pendulum the other way to the point where if you can read this to say that the burden is on you, plan fiduciary, advisor, plan sponsor, as to why you didn't consider climate change and other ESG factors. It really flips it on its head in a way that we think goes too far, in a way that we think for the first time, the department is interjecting its own views on investment methodology and philosophy or policy that they've never done before, in a way that the industry is not prepared for, because one, there's not agreement on definitions and nomenclature. The SEC is still working on that. And two, there's not consensus on how to screen these investments. I mean, you can have the same investment that you screen under Morningstar and MSCI, and you get completely different results. So you're implying that we have to do something that practically we can't do. And third, what we're worried about is, are we now getting into a situation where we're just going to be flipping and flopping every time there's a new administration? And that's never, as we've discussed, good for retirement policy, and particularly not good for long-term investing. And so, we want to try to get with them. We're getting mixed signals as to what the intent is. I think the problem here is that there's a difference of opinion among the career staff at DOL and the White House. A lot of this language is from the White House. And, what we're worried about is the politicization of this in a way that's going to be impractical and create litigation risk in an already ridiculously litigious environment for ERISA plans. So I want, to the extent you're not aware of this, I wanted to bring it to your attention because it is very concerning to us. We like ESG. We think ESG is a good thing. We've got a great education program, ESGK, for plan advisors that hopefully you're familiar with. But for us, this would be about a level playing field for ESG, not some implied requirement that all investments, not just ESG investments, but all investments should be screened for ESG factors and climate change, separately stated in the rule and in the preamble. And so that's a bridge too far, and we think it's important to try to swing this thing back to level. All right, I am going to stop here. We've got 5 minutes to go and see if anyone has any questions.
So if you do have any questions, please enter them into the Q&A module at the bottom of your screen, and we'd be delighted to share them with Brian for his.
And while we're waiting on them, I will tell you the other thing that DOL is working on that's of import to plan advisors is a proposed rule, which we do expect by the end of the year, on the definition of investment advice. And in particular, what that means is that they're going to revisit the 5-part test. No, I do not expect them to bring back the best interest contracts standard, which obviously was thrown out by the Fifth Circuit, but they certainly, it's within their jurisdiction to revisit the 5-part test. And in particular, I expect them to revisit it vis-a-vis retirement plans. Because if you give advice to a plan sponsor, that's not actually covered by Reg BI. Institutional advice is exempt from Reg BI. So you've got a bit of a policy gap in that if I sell a plan sponsor, a retirement plan is kind of a one and done transaction, you don't have a regular basis standard met under ERISA, Reg BI doesn't apply. So basically there's no protection. And that's really not a good place for the world to be at. So I do expect the regular basis standard to be eliminated, at least with respect to retirement plans, and maybe even in a more broader sense. I believe they'll probably tighten up a little bit about what constitutes education versus advice as well. So I would expect even it would be surprising if we're not tilting even more towards the fiduciary standard for all ERISA, or a best interest standard for all ERISA related advice.